Good morning and welcome to the 33rd meeting of the Economy and Fair Work Committee in 2025. I begin by noting the apologies that we've received from Sarah Boyack, Willie Coffey and Stephen Kerr. This morning we have two matters to consider in our public deliberation. First of all, an item of subordinate legislation, and then secondly, the Digital Assets Scotland Bill, on which we will be beginning our Stage 1 consideration. So moving to Agenda Item 1, which is consideration of the Public Procurement Agreement on Government Procurement Thresholds, Miscellaneous Amendments, Scotland Regulations 2025. This instrument is subject to the negative procedure. It amends the financial thresholds for when Scottish procurement regulations apply to the award of contracts. Scottish ministers update the thresholds every 2 years to reflect currency fluctuations. No motion to annul has been lodged. I therefore invite the committee to note the instrument. Are we all agreed?
Agreed.
Thank you. We now move to our opening session in terms of our consideration at Stage 1 of the Digital Assets Scotland Bill. And I'm delighted that we have Lord Patrick Hodge and Professor David Fox with us. Lord Hodge is Deputy President of the Supreme Court of the United Kingdom, and Professor Fox is Professor of Common Law at University of Edinburgh, and both of whom were members of the expert reference group convened by the Scottish Government on this area. You have not asked to make opening statements, so I'll just begin by opening up the questions. And I guess I would like to say at the outset, with the exception of Murdo Fraser, none of us are lawyers, so please bear with us if we're asking basic questions. But having looked at this bill and also read through your report to the government, I would just like to ask you both whether you are content that the legislation meets the requirements and suggestions that you made in your report. Lord Hodge, may I invite you to answer that question first?
The answer is yes. The background to this was that people have been treating digital assets as property, although it's not clear that the law recognises them as such. And there have been several national and international initiatives to recognise digital assets as property. And the ERG, the working group, thought it appropriate that Scotland should protect its financial technology and asset management industries by putting the matter beyond doubt in Scots law. The paradigm current technology is the distributed ledger system, of which blockchain, I think, is the most well known. But technological developments in future will create new forms of digital assets. So the aim of our report was to recognise as property things that people in the commercial world are already treating as property. And our aim was to be technologically neutral and to provide a minimum of definition in the legislation to allow for unforeseen technological developments and commercial innovation. And the problem that we were addressing is that digital assets don't fit neatly into current legal classifications of property in Scots law. And this was the same problem as the Law Commission in London faced in relation to English law, and their work on digital assets has led to the passing, I think in very recent days, of the Digital Assets Bill in London, which awaits royal assent. And what they've done there is create legislation recognising as a form of property something that doesn't fit into the standard English classifications of things in action and things in possession. Because there is a considerable volume of commercial case law in London, the Law Commission recommended a very short bill which simply recognised the possibility of there being this third category of property. Here in Scotland, we are dealing with a different legal system, and we don't expect the Scottish courts to have the throughput of case law on the same scale as exists in London. And that's why we've recommended the Scottish Bill should have more provisions to clarify how digital assets fit into our wider law, such as how the ownership of digital assets is transferred and the application of certain general principles of Scots law. After we produced the report and the Scottish Government chose to go ahead with our recommendations, we had meetings with the parliamentary drafting team on the terms of the bill, and they were very productive. And I would like to record our appreciation of the work of the parliamentary drafting team, who behaved very well, and we admire the skill with which they conducted their work. So that's a rather long way of saying yes, we think that the bill reflects our recommendations.
Professor Fox?
I have very little to add to that, merely to emphasise that this is a bill designed specifically for Scottish property law. There are special peculiarities of Scots property law which need to be allowed for in the definition of digital assets. Having said that, however, it is designed with a mind to developments in other legal systems and other international conventions governing digital assets, notably UNIDROIT, and the work of the England and Wales Law Commission, which has led to the bill which Lord Hodges just referred to. So it is an internationally informed piece of law reform, but one which is designed specifically to meet the doubt which has been mentioned about the existence and the categorisation of digital assets in Scots property law. So, yes.
Just looking at the definition, also your report, I think two questions occur to me. Colleagues will delve into some of the details in greater depth, but in essence, it requires the asset to be rivalrous, and I just wonder whether or not there are potential issues there, both in terms of the exclusivity that may or may not confer, because not all digital assets do, and I think there's sort of you can understand a concept where these things have restricted access, but not necessarily exclusive or unique. And likewise, are there digital objects, but that we may not be seeking to capture, but may inadvertently do so because they do confer exclusive or rivalrous control, but aren't the source of non-fungible tokens, which I believe is the terminology that are being used for financial exchange, but just a matter of sort of IT security, passcodes, and so on and so forth. And is there any issue with sort of inadvertent capturing of other aspects that we're not seeking to in this legislation?
Yes. Can I just begin with one very general comment about the definition? Then I'll go into some of the technicalities which you're raising about its application. So, the very general point is that there are different ways, including different legal ways, of defining a digital asset. Any definition that we formulate is always expressed in terms of the purpose of that definition. Now, this is a definition which has the purpose of recognising or clarifying the status of digital assets as objects of property for private law purposes. So some of the terminology which we would use, like rivalrous, it's not a word you generally find in ordinary discourse, Nor one that's easy to pronounce, by the way. These terms are ways of picking out key characteristics of digital assets in order to recognize their status as objects of property. So this is a definition formulated for the purpose of property recognition. So, just to make a quick comparison before I go on to more detail, there are other legal definitions of digital assets in legislation in the UK. Notably, for example, there is one in the Financial Services and Markets Act that refers to a cryptographically secured digital representation of value. Now, that definition works well for the purposes of the regulation of financial markets, but it would not work as a definition for the purpose of the recognition of a digital asset as an object within property law. The definitions are therefore different across the different ranges of application. So we have a definition designed to capture the key characteristics that a thing would just need to work as an object of property. Now, another point which might be apparent from some of the consultation papers is that this is a legal definition for property purposes, but many people in ordinary discourse will talk about digital assets in a much broader and looser way. So necessarily there'll be some things which some people will think of or call digital assets which don't necessarily meet this definition. To some extent they are deliberately outside it because they won't work for the purposes of property recognition. But there is also the point you make that we need to be sure about not inadvertently over-including and capturing certain other kinds of things which might appear to fall within its terms but shouldn't be within its terms. The second one is actually easier to deal with first. Can I do that one first, if that's all right? So, you mentioned, for example, passcodes or access codes. Notably, for example, a private key, which might enable a person to transact with their digital asset on the system. That private key would not actually be a digital asset. It would nonetheless be protected by law through a different kind of regime. So your private key, for example, would be confidential information. It is protected through that legal route, but it would not actually pass the test required to be a digital asset and therefore qualify for the very special kind of property protection that would come from that property status. So the nature of rivalrousness would actually prevent certain kinds of related confidential information from coming within the terms of this bill. Now, in terms of what is included within it, there are many, many things which some people in general usage may refer to as being digital assets, but they will be deliberately outside this definition because they won't pass the tests contained in section 1.1. And the main reason why they are outside it is not inadvertence, it's the fact they simply would not work if we were to treat them as property according to ordinary property principles worked up by the general law. Now, one of the common examples that people make is to say a person's email account, their private email account, is in some sense a digital asset, but it's not a digital asset for the purposes of this bill because it simply could not be property according to the ordinary understanding of what property actually is. So the definitions we have in section 1 are general criteria about what makes things workable as property, and therefore certain kinds of assets just don't fall within those definitions. They are deliberately outside its scope. Does that address some of your concerns?
I think so.
Yes.
I may need to go away and consider that. Lord Hodge, do you have anything to add at all?
Not very much. I mean, the key concept of rivalrousness, again, a difficult word, is that you can't sell the same thing twice.
Yes.
So the idea being, once you have transacted in it to give it to someone else, you no longer have it, and therefore you can't give it to a third person. And that is an essential quality of property. So that is the limiting factor. If I've got a photograph on my telephone of my grandchildren that I want to send to their uncles and aunts, I can send it. They receive it, but I still have the photo. That photo isn't property. It's not rivalrous. That's just an example. It's a limiting factor which is designed to reflect the nature of a property right, and similarly, existing independently from the legal system, that again is a concept that is designed to achieve that effect. For example, a tree is a tree, even if there is no Scots law, and my wallet is my wallet, even if there is no legal system. So it's looking at what people treat as things independently from the legal system that gives its characteristic as property.
Thank you. I believe Michelle Thompson, Deputy Union, would like to ask a brief supplementary.
Thank you. Good morning. And I would also qualify by saying I'm not a lawyer, so if you think I'm about to ask a ridiculous question, please suppress your laughter. What I was wondering about was, in terms of the definition of a digital asset, and I know you will have considered the advent of artificial intelligence, and particularly generative AI, where an asset could be part of the generative thing is it's evolving. It's never the same thing twice. The whole part of that particular package is that it's got some definition. It may have some descriptor around it, but it could be eternally evolving. How within this legislation, I mean, the point at which the packet transfer would take place, the packet will be the descriptor of what the generative AI piece of technology is, and that's the only thing we've got to hang on to. But how do you square that kind of situation off with your definitions thus far? And I appreciate you've taken cognizance of by making it as simple as possible, because we don't know what we don't know, and I think that's one of the key challenges. But just thinking about, because we're not that far away from that, I hope I've been sort of clear.
Well, I am not a technical person. I'm merely a lawyer, and I claim no expertise in the world of AI. But AI is going to pose serious challenges to our legal systems. Of that, there is no doubt. Our law of contract, our law of delict, our law of intellectual property, all these things. We haven't sought to address the phenomenon of what is created by AI in our recommendations or this bill. But if AI were to create something which met the definition which we have here, it would then be a digital asset. If that which AI created did not meet the definition, it would not. We haven't sought to tackle AI. Tackling AI is going to be a major problem, both nationally and internationally, for lawyers to get to grips with. I don't know, David, if you want to add anything.
Yes, this is not a definition directed specifically at AI-generated entities. The big question would be, in terms of definition, whether that evolving kind of entity was in some way rivalrous. Now, that would depend, I think, upon the existence of some kind of programmed or human control over the way that system was generating the entity. That would then become a question of almost digital fact and evaluation, measuring the operation of that system against the general criterion of rivalrousness. There is one other thing to say as well, which is that irrespective of whether we treat this AI-generated evolving entity as a thing for the purposes of ownership, there may well be other kinds of property right recognised in relation to it. In other words, there may be a question whether that AI-generated entity is the subject of some kind of intellectual property right, like a patent or a copyright. So property involves a lot of different kinds of rights and related regimes, and it may well be that other parts of property law, particularly intellectual property law, would provide the forms of control and protection for the sort of entity that you have in mind.
Okay, thank you.
If I should just add.
Of course.
If I could just add, we have had a case in London about patentable rights where an inventor was arguing that his AI machine had created a new device which should be patentable. And that ultimately involved an interpretation of the current patent legislation. And we, in line with most other European countries, looking at their own patent law, said no, it's not patentable because our legislation assumes human agency. And this is part of the problem that we're facing, that our law of contract, our law of delict, our law of intellectual property all assumes human agency. So if a machine creates something, at the moment our laws don't cope with that. And that gives you an idea of the extent of the challenge that we're facing.
And I can see how you're making that backwards linkage into other areas of law at the present time, but I still think there's a potential challenge. I mean, something would be flushed out if there's intrinsic value. Somebody's going to come forward and, you know, that's it, the nature of it. But if there's something that lets the amorphous thing constantly changing, I think it'll be very hard unless somebody steps forward with it believing intrinsic value or it butts into other areas of law. Okay, so, I mean, I don't expect you to have the answer to that because we don't even have the questions. But I suppose, you know, it's fleshing out the sufficient flexibility in what has been determined thus far to at least take account of what we think we're starting to imagine are some of the issues. And it sounds like you're more confident about that.
I could take that point. So, you spoke about this amorphous kind of entity having some kind of value associated with it. The way that would be tested for the purposes of our bill would be if the creator, whoever that person or thing might be, of that entity, tried then to sell that entity to another person, a human being. Now, for the purpose of that kind of transaction, the amorphous entity would need to be a thing, and it may well be that that is where the bill we're considering today would have some traction in relation to it. We would therefore begin to ask the question whether that amorphous entity was rivalrous and whether it did exist independently of the legal system. Clearly it does. It passes the second test. No trouble. Whether it's rivalrous may just depend upon whether there is the necessary human agency controlling the reshaping of this entity, that we could say that other people are excluded in a way from the reshaping of that entity. Now, I'm working this out in my mind, as you can probably see, but I can actually see in these terms here some very general criteria which would at least begin to set the question running as to whether you could actually imagine transferring ownership in that amorphous entity from one creator to another creator. And that, of course, is separate from these other questions of intellectual property protection, which the creator may have in relation to that amorphous entity. So, yes, there are criteria here which could certainly begin to answer some of the questions which you're now asking.
If I can just ask one final question before I hand over to my colleagues. I note in your report one of the specific recommendations that you made was that there should be clarification regarding trusts, given that it's a very common arrangement for these objects to be held or owned by trusts. And certainly on my reading of the legislation, I wasn't clear that the bill provides that clarification. I mean, I just wanted to ask whether or not you're happy with that, given that the bill does set out that these things are property, and therefore, given that trusts are capable of owning property, therefore it's covered. But I just want to ask for that clarification, as it was one thing that I noted in your report that I wasn't clear was in the bill. Lord Hodge.
We have in the bill gone further than, or rather the Scottish Government in presenting the bill has gone further than the English legislation, which is really skeletal. But when one recognises the subject matter as property, then our trust law will allow trusts to be created over it. I think we recommended that one might state that expressly for the avoidance of doubt, but I'm personally satisfied that you can create a trust over the digital asset as recognised in the bill.
I assume that was the answer, but I thought I'd ask the explicit question just to be clear. With that, I'd like to hand over to my colleague, Lorna Slater.
Thank you, Convener. I've got questions relating to the sort of future-proofing of the legislation and your comfort with where it currently sits. Firstly, the bill's definition of digital assets requires an immutable record from the electronic system involved. Does this have the potential to limit the adoption of future technology if it doesn't operate like current blockchain?
I'll take that one. Thank you. Yes. We do need a future-proof and tech-proof kind of definition for digital asset. That's why it's all being expressed largely in terms of general property criteria. We are deliberately choosing a definition which is not dependent upon any particular conception of the technical system it might be applied to. And in fact, I would not read this definition as being specific to blockchain technology. Now, if the key word is immutable, I understand the point that immutability is a concept best known because it's often associated with blockchain technology. One of the supposed features, and I will say selling points, of using blockchain technology to deliver assets is it's assumed that the blockchain record cannot be changed unless there is some overwhelming change in control of the way that the blockchain operates. The typical assumption is they are immutable. But I think we'd read that immutability as being a property feature, a general property feature of any kind of system where you have property constituted by records of the sort that we have here. The point being this, that if some other person has an open or arbitrary power to change the form of the blockchain, to change the form of the record generally, then, to use a metaphor, it's a very leaky kind of asset. It's not a secure kind of asset. There is a way in which the integrity and the security, and in that sense, the immutability of the way the asset appears on the record is just essential to its workability as property. So although the word immutable does have very strong connotations connected to blockchain technology, I see it more as being a feature of any kind of record-based system of property. And therefore, this definition would not be confined to blockchain technology. And I don't think it will be necessarily superseded if other kinds of asset emerged which depended on a different kind of ledger system to deliver them.
If current systems were to develop that did allow changes in limited circumstances, for example, in fraud, is it fair to deny any potential property items arising from those systems recognition under the bill?
Immutability is a relative concept. It's a very strong word, but it does have to be read in a practical way as a relative concept. So even if we take those systems which nowadays are generally touted as being immutable, like the Bitcoin blockchain, for example, we know that there are, in fact, ways of changing the rules of the system, in effect, that might enable then the state of the blockchain to be changed. Now, as I see it, if we imagined, and it would be imagination, if we imagined a system designed so that the system controllers had the power to reverse, on the blockchain, a transaction procured by fraud, let's say, I don't necessarily see that as taking those assets outside the definition contained in the bill. Some limited power of control expressly provided in the way the system works seems to be still quite consistent with the immutability of the system. What matters, what will be worse, or what would be a problem, would be if the system could just be tampered with in an unauthorized way outside the terms of its own neatly defined rules. That would be a problem. You would then have a kind of system which was leaky, and where it would then become possible just to spend the same asset twice, and that would therefore deprive that asset of the essential rivalrousness that it needs just to work as property. So some limited degree of, as it were, controlled, rule-based interference coming in the operation of the system, I don't see as being an absolute objection to the rivalrousness of the assets created on that system.
Thank you. Now that's very clear. Thank you. So things which will be recognised as digital assets under the bill, we're looking at tokenization, which is an emerging use of digital technology but isn't dealt with directly by the bill. Would you be able to share your views on the concept of tokenization and whether certain types of tokenized assets are likely to be recognised as digital assets under this bill?
Yes. It may be easiest to begin with an example for the rest of the committee. So a tokenized asset would be something like this, a digitized share security. So at the moment, people hold securities, they hold shares in companies, and they will trade those shares on electronic register systems. That's the CREST system in the UK. Now, the development which is already happening, it's becoming mainstream, is that rather than use those existing forms of electronic register, the securities, the shares are issued on a blockchain. They are connected with a particular token created on that blockchain. And the way people transact with the security, the share, is just by transacting with the token on the blockchain. So if I want to transfer my share to you, I transfer my token, which is connected to that share, to you, and the rest just follows. Now, would those sort of transactions, which are actually economically more important, I think, than the best-known ones like Bitcoin, yeah, would those sort of transactions come within the bill? Categorically, yes. The token would categorically pass the definition of being a digital asset in the context of Section 1. So when we say the purpose of this bill is clarificatory and it's designed to give reassurance and certainty to commercial actors, it's that kind of transaction that we have in mind. So yes, these would be, tokenized securities would fall within the terms of the bill.
Thank My final question is a slightly more general one, just to I think you've covered this, but I'm just going to get you to say it explicitly for the record. Do you think the requirement for a potential property item to exist separately from the legal system is clear enough in this bill, given the ongoing debate about the extent to which this is possible for digital assets?
Yes.
Okay. Good answer.
But I will give my reasons. Now, can I just take the general point about the need for independence from the legal system first, and then I'll do the next point, which relates to your previous question about tokenized assets. So, why do we say that the assets must exist independently from the legal system? This goes back to Lord Hodges' example a few minutes ago about the tree and his wallet. So, one characteristic of objects, entities, things that makes them actually work as property is that they can carry on existing regardless of whether there is a legal system actually applying to them.
Okay.
The tree is still there, it is still available to be owned. If a legal system comes into existence to constitute that notion of ownership in relation to it. So, the purpose of this bill is to explain key features of digital assets, almost by analogy with those physical objects like trees. So we put in the independent from the legal system criterion to do that part of the work. Then there's your next question about tokenized securities. Now they are peculiar kinds of thing. As we've seen, there is this token which is being transacted with on the blockchain, but that token is linked to, connected to, the security which in some way it stands for. Now, there may be a doubt about whether that sort of tokenized security really does exist independently from the legal system, because the security is a product of law. It is a creature of law in the way that the tree or the wallet is not. Now, I don't see that as being a problem. The main thing is we just need to know that the token which is connected to that security is property. I could leave it there. There is one stage more I could say. It would make it a little technical. I'll just say, yes, I'll give the technicality. Now, the tokenized share, the tokenized security, is a kind of composite.
It's a record.
Yeah, it's a record made up of more than one component part. Yeah. There is the record that says it's in you as opposed to me. Mm-hmm. There are all the legal rights created by law, which confer upon you rights against the issue of that security. Those don't exist independently of law, and there is the token. Mm-hmm. The whole thing is a composite coming together. So we're targeting the bit of that composite, which at the moment is still uncertain, i.e. the status of the token itself as being property in law. There is no doubt that the share is property. That's traditional standard property law.
Really clear. Thank you very much. Thank you, Convener.
Thank you. I'd like to hand over to Kevin Stewart.
Thank you, Convener, and good morning. I'd like to look at acquiring and transferring ownership, and some aspects of this were covered earlier on around about the Westminster Bill and that third classification, as Lord Hodge mentioned. The Law Commission in England and Wales considered the concept of control of digital assets to be too nuanced to be helpfully codified as legislation. Do you think that this bill benefits from the use of control as a concept?
reasons. For one thing, this bill goes further than the Westminster Bill does, in that it does attempt some very general definition of what control would have to consist in. That's contained in Section 5. So in that sense, it is more prescriptive than anything contained in the Westminster Bill. There is a reason for that. The Westminster Bill is all premised on the assumption that they will leave a great deal more of the general working out of the content of digital assets to be done by the judiciary in the course of deciding disputed litigation. We are slightly more prescriptive than they are because we don't contemplate that same volume of litigation coming before the Scottish courts. Now, that explains why there is an attempt to define what control means. Now, the second thing to say is that if you look hard at this definition of control and you start thinking about some of the more complicated control arrangements that apply to digital assets, there are marginal difficult cases. So, for example, there are some cases where more than one person has some share of the control, of the entire control over the digital asset. We call those multi-sig arrangements. Now, none of that is expressly provided for in the bill, but again, that's deliberate. What we contemplate is that the way this definition of control works will be read in the light of well-established industry practice. And in particular, we know there is already underway work from the UKJT Committee on Technology to formulate general system-neutral definitions of what control might mean in the context of digital assets. So we provide a very basic definition of control here, but there will be, as it were, official guidance coming from the UKJT Committee about how you would apply that general concept of control in some of its more difficult applications. And all of that will be publicly available. The work's been going on, I think, for the past year or so, and something should come to light, I hope, early next year.
Okay, thank you. Exclusive control could be argued to be a legal fiction in many real-world situations relating to these digital assets. An example being when private keys are shared or assets are held in digital wallets. This could be said to lead to the presumption of exclusive control in this bill. Is this the best way to legislate, in your opinion?
Yes. The exclusivity of the control is, in a way, not a function so much of the digital applications of how transactions might get authorized. That is one of the key property criteria. So there needs to be some notion of exclusive control in order to make the asset rivalrous, in order that it can work as property. Now, having said that, there are these difficult cases on the margins, which you mentioned, where you have a digital asset in a wallet, or where more than one person has some input into the control and the signing of those digital transactions. It's precisely those situations which the UKJT Committee is designed to give guidance on. The simple fact that more than one person has a key which might be used to implement a transaction on the system, that of itself does not give each one of those people exclusive control. It will depend upon very often the count as to how many signatures are required out of all the key holders in order to make the necessary transaction on the system. So there are ways of still determining who's got exclusive control, even though in some situations there may be shared control arrangements applying across more than one person. And we expect that we'll get guidance on that, which judges can work from in the UKJT report when it's published.
Convener, I've one more question, and it may well be a daft laddie question, but you know, we've talked this morning around about artificial intelligence and it coming into play, and you talked there, Professor Fox, of a person having control or shared control. What if some of that shared control is not held by a person, but by artificial intelligence?
Yes, that is a problem, and it's another indicator of the more general problem which Lord Hodge, I think, has alluded to at the start. Most of our notions of private law, including ownership, assume that there is a person who can exercise that ownership. What I would say is that all those larger problems about how you fit AI into private law they're other and different problems, which this bill in and of itself can't directly address. It's got a more limited range of application, which is just to determine whether the things created either by human agency or possibly by machine agency can be property within the system. So we don't in any way rule out the possibility of needing to address some point in the future who we attribute the ownership of these AI-generated entities to. That possibility is still there, but it may well be a problem for another day, but it's part of a much, much larger problem than one that this bill can address.
May I,
Please.
may I just add, I endorse that completely. One of my concerns about the effect of AI on our law is that we will have machines making decisions. We will have machines causing people loss. And where is the remedy for the person who causes loss? One option might be to give personality to certain machines and require compulsory insurance. There'll be various options, but that is a much bigger issue which this rather modest bill cannot address. But it is a problem to which I'm very alive, and I have in fact lectured on the problem, merely to identify it as a problem, not as yet to give an answer. Thank you.
Thank you very much. Thank you, Convener.
Thank you. I think it's a very interesting topic, but I will urge members to move on. Can I bring in Murdo Fraser?
Thank you, Convener. Good morning. I should remind members of my interest. I'm a member of the Law Society of Scotland, although not currently practising. The two issues in the bill I want to try and explore if I can. The first is the question of acquisition in good faith, which is covered in Section 4, subsection 2 of the bill. And the bill provides that someone who acquires a digital asset in good faith and for value can become the owner of that asset, even if the person selling to them is not. And I just want to understand the rationale for this, and perhaps for the benefit of the millions at home watching who might not be lawyers, illustrate it. Let's imagine Daniel owns large sums of Bitcoin, and I'm a nefarious international criminal in some foreign jurisdiction, and I hack Daniel's account and get access to his key, and then I sell his Bitcoin to Gordon, who's a good faith third-party purchaser. Under the bill, Gordon is protected as long as he pays value, but Daniel has lost his asset and is deprived of it. Now, in theory, he has a remedy against me, but I'm hiding in the back streets of Montevideo or Lagos, so that's valueless as a remedy. Is it fair that the purchaser is protected in those circumstances as opposed to the owner of the asset?
If I can take that question, the For those who are listening, perhaps I'll explain the concepts of good faith and for value, and then address your challenge, if I may. The protection given to a purchaser for good faith and for value is a protection for people who are honest in their dealings. It exists in our law of the bills of exchange, and also it exists to protect people who obtain property from a trustee who acts in breach of trust. It's a well-established principle in our law. It involves two separate requirements. You can acquire an asset in good faith without paying for it, a gratuitous acquisition, or you can pay for an asset which you acquire without being in good faith, and in either circumstance you don't have protection. You need to be both in good faith and to have paid for the acquisition. So a purchaser in good faith is someone who buys the asset without having notice at the time of purchase that the person other than the seller, i.e. the third party, owns or has a right or interest in the asset. And the purchaser for value is someone who has to give a full or fair price for the asset. Now, why prefer them over the owner? I think you have to look at the principal purpose of the legislation, which is to develop and encourage the development in Scotland of the legitimate use of the technology. And that will be things, as Professor Fox has said, like the transfer of tokenized securities, rather than the slightly wild west we live in at the moment in relation to cryptocurrencies. One of the critiques of the process of recognising digital assets of property, Professor Robert Stevens, thinks the whole thing is misconceived because cryptocurrencies, in his view, are a device for speculators and criminals. And of course, there is some truth in that assertion. But we're looking ahead, and we're looking to what actually is happening, is that there is legitimate and proper uses of this technology. And the technology will be used for transferring assets from A to B. And we learnt in the 19th century the importance of negotiability, the ability to transfer, in those days, a piece of paper from A to B, which gave you a right over another asset, let us say, or a right to demand payment from someone else of money on a certain date. That's the classic bill of exchange. And it was very important to encourage the use of these things in commerce to protect the bona fide purchaser. That is why we are doing it as well, to enable the negotiability of these assets from A to B to C, without having someone coming long after the event and saying, well, actually, you got it from B, B didn't own it, I did. It is really to encourage the commercial use of these things that we are creating this negotiability.
Thank you. So you explained the rationale for that choice well. Maybe I could just tease out some of the detail a little bit more, because what would be your understanding of the requirement in the bill, Section 4, subsection 2, of good faith? How would that be demonstrated in practice?
Well, you would have to establish that you did not know that the person from whom you were receiving the asset had a defective title. The burden would be on you to show that you were unaware of the defect in that person's title, and it would be for you to establish that.
And would there be any requirement on the purchaser in that scenario to have done any form of due diligence, or would it simply be a negative?
It would be, I think the whole idea of negotiability is that if you haven't got notice of a problem, then you're entitled to take the thing and give value for it. So there wouldn't be a due diligence requirement.
Okay. Okay. Thank you. The bill provides that the purchase must be for value, but the expert reference group had suggested the term onerous consideration. Have you got any view on why the bill uses a different language?
Well, I would treat the terms as interchangeable, and one talks about one often talks about an asset being acquired in good faith and for value, and when we speak about onerous consideration, I think we're using the same meaning essentially. I have no concern that that meaning has changed through the different wording.
All right, thank you. I touched earlier on the issue of a remedy for the true owner who's deprived of his asset because a criminal has acquired it and sold it on. Some of the respondents, when the consultation was done, suggested some remedy could be provided. Did you have any view on how a remedy might be constructed in those circumstances?
I see the remedies as being those of the general law, that if someone has deprived you of an asset, and if he or she has transferred it to another, and that the third person has got a good title, you can no longer recover your asset, but your claim will then be in damages against the wrongdoer. Now, it is of the nature of these assets, as we see in the form of cryptocurrency, that they are quite often difficult to track, and we all know that there are bad players out there using cryptocurrencies for nefarious purposes, and we know that there are people there who are selling non-existent cryptocurrencies and defrauding people. All that is true, but our aim is to protect legitimate business, and the methods that are available in the general law should be made available in this circumstance without further legislation. So if you can identify the wrongdoer, and if he or she is within the jurisdiction, and of course with some of these things quite often they're not, as you know, then you can sue them for damages. But the effect of the good faith and for value provision will mean that you can't go against the ultimate acquirer of the asset in the same way as you couldn't go against the holder for value of a bill of exchange.
Okay, thank you. Maybe I could ask a slightly different question, which is to do with other areas for law reform, because we appreciate this bill is very tight in terms of the areas it covered, but a number of the respondents to the committee's call for views identified other areas where the law needs to be addressed. For example, private international law, where do these assets exist? If somebody were to die, which law of succession would apply, for example? What is your thinking around further law reform in this area, and what work's being done, and how quickly might that proceed?
Well, thank you for that question. A very obvious problem when dealing with assets in cyberspace is that they're not located in any particular jurisdiction, and therefore there is a need for ideally an international understanding of which legal system and which which courts of which country have jurisdiction to deal with the matters. Now, in an ideal world, and of course we're acutely aware we don't live in an ideal world, in an ideal world we would have an international agreement governing this matter. Now, that may be quite a long way away, because getting governments or countries which are in competition with each other in relation to the development of digital assets to agree such rules will not be an easy task. In the absence of such an agreement, there would be benefit in establishing domestic rules of private international law to establish the legal system which our courts will recognise and apply to a dispute, and also recognise the jurisdiction of a particular country. That at least is a first step, because in my experience, when countries adopt rules of private international law, which other countries look at and find acceptable, they often adopt a similar rule themselves. So establishing our own rules, I think, is an important first step. And the Law Commission of England and Wales are addressing the questions of private international law in their current 14th programme of law reform. They have published a consultation paper on this matter, and they plan to report on it next year. And that is something that I think we in Scotland should be looking at. It may be a subject for which the Scottish Government will wish the advice of the Scottish Law Commission, or it may be that they will ask the expert reference group that Professor Fox and I have taken part in to reconvene to look at it. I don't know, but it is something that we ought to be addressing. There are other areas as well, as you have seen from the consultation responses which have been raised, and of which we're aware of law reform, which may need to be addressed, like diligence, the creation of security over property, and questions of getting information to insolvency practitioners to track down these assets, which are quite easy to hide. These are future areas of law reform which I think we should be thinking about.
Right, thank you very much.
Thank you, Murdo. I'd like to bring in Gordon MacDonald.
Thanks very much, Convener, and good morning. I've got a couple of points I wanted to ask just for clarification. First one is about a panel of experts. So the Law Commission in England and Wales recommended the establishment of a panel of experts to advise judges on technical issues in relation to digital assets. And Professor Fox, you mentioned the peculiarities of Scottish property law. So how do we ensure that separate needs of Scots law are adequately considered in relation to this area? Do we need a separate panel for Scotland, or should we have representation on the English panel if possible?
I'll take that one. Thank you. Yes, just to recap what I said earlier, as you've said, it was a recommendation in the England and Wales report to set up a separate panel. That has now been set up. It's under the chairmanship of Lord Justice Zaccaroli in London. It has convened a group, mainly of, I'm going to call them well legally informed tech people, who are formulating notions of what control means for the purpose of digital assets. Now, for one thing, the intention is that their work will be publicly available. It's not a closed club in any way. The plan is, and I think this will be true, that much of what it says about control should be neutral to any particular legal system. Now, the reason for saying that is that the thinking that underlies the reasoning in this bill, that underlies the England and Wales bill, that underlies international conventions like the UNIDROIT draft principles, is that control is essentially a factual process. And the way we ascertain, for example, what it means to have exclusive control over a digital asset is not something which is peculiar to any particular legal system's notion of property. It is an applied question of technical fact. So we would fully expect that any guidance coming from that panel chaired by Lord Justice Zaccaroli would be applicable in this country. So I think we would be reinventing the wheel to do it all again in Scotland, but that doesn't in any way undermine your point. It would be a good idea to have some specifically Scottish representation, just to be aware of any peculiarities in the application of control across more than one jurisdiction. But much of the work is already being done and will be available to us.
Okay, that's very helpful. In terms of regulation-making powers, do you think the bill would benefit from the inclusion of additional regulation-making powers so that the definitions in relation to digital assets and the concept of control could be adjusted in the future without the need of primary legislation?
If I could deal with that question, we do have a regulation-making power in the bill, but as you will have seen, it is dealing with matters which are designed to really deal with matters that are consequential, transitory, and supplementary, rather than a wider power. One could, I suppose, have a power that could extend the scope of the recognition of property. But I would be worried about using a regulation-making power which might have the effect of restricting or taking out of what the Scottish Parliament has recognised as property, something that is already there, i.e. removing someone's property rights, because that would raise questions of the first article, protocol number 1 of the European Convention, the removal of people's rights. And also there's a constitutional question as to whether one should be removing property rights by subordinate legislation.
Is there a question about being fleet of foot in the sense that digital asset technology is moving faster than any legislation, so therefore we have to have that ability without going through primary legislation?
Well, I fully understand that, and one of the motives for keeping the bill, the terms of the bill broad, the definitions broad, was to allow technology to develop. The idea is to be as expansive as we can within the confines of the concept of property to allow such development. As I say, a regulation making power to extend the concept of property to new digital assets is one thing. A regulation making power to remove property rights from something that already exists is another. So one could have a more extensive regulation making power. My concern will be I'm aware that this is quite a short session of the Scottish Parliament in the lead-in to the next elections, and I personally would be keen to get what we can on the statute book when we can, rather than provoke a controversy about the extent of regulation-making power at this stage. I don't know if Professor Fox has any other comment.
Just a very small thing to add, which is that even if there were a regulation giving power to recognise different kinds or new kinds of digital asset, those digital assets would still need, as a matter of fundamental property law, to fall within Section 1.1.
Yes.
In other words, we don't have a completely open choice about what kinds of digital asset we will call property. The point being that property law has its own criteria which make certain kinds of entity workable as property. And in some respects, those don't change. So the fact that there may well be new kinds of digital asset class invented doesn't of itself mean that we can just include those regardless within this definition. To a degree, this definition exists independently of advances in technical use. So, to reinforce Lord Hodges' point, I would have reservations, I think, about certainly now, including a general power to add new items onto the list. Because whatever happens, the items must satisfy the definition in 1.1, otherwise they just can't work as property. Okay. To go back to an example from the very start, for example, let's hypothesize, imagine, and I'm going to say it is no more than that, that we decide, or regulators decide, to call a private key property. In a way, that can't work, because even if you call the thing property for the purposes of the bill, it just cannot satisfy the key definitions contained in section 1.1, because those key definitions reflect fundamental characteristics that any kind of thing that is to be property must just have. So I think there would be quite a strong gravitational argument against actually adding new items into the list.
Okay, thanks very much. I'll leave it at that.
I wonder if I may just ask one last question. And Lord Hodge previously referenced some of the innovations that occurred in the 19th century and this being analogous to them. And certainly, I mean, I think, I'm somebody that's always fascinated by the way patent law occurred. And in a sense, that's, attempting to provide legal constraint and control over something even more ethereal than something electronic, which is ideas. But it did make me wonder, is it fundamentally right to look at, in terms of this bill, at the source of where these things have emerged, i.e. electronic systems, as opposed to, and again, we've spent a long time this morning actually talking about the nature of the relationship of the individual and a register. And is there an alternative approach which actually looks at the function and the rights and responsibilities that flow from that function of registration rather than the essential source that these things have emerged? Because and if you look at perhaps some of those innovations in the 19th century, they focus more on the way that the wrapper and the conditions of those things operated rather than the thing itself. I hope that's clear as a question, but it's just.
You saved the most difficult question for last. Yes. Can I begin like this? So you refer to intellectual property.
Yes.
Now, intellectual property is not like that, or it's not like the tree which Lord Hodge has mentioned. It does not have an existence entirely independent of persons or the legal system. It is, to a degree, a kind of imagined concept, yes. Which we then give legal protection to. We create the intellectual property right, as it were, out of nothing.
Yes.
Now, there is, in that sense, a certain analogy between that and the digital assets we're considering in this bill. They are, to a degree, imagined concepts. But in order to work as property, we need to think of them as things which have the necessary property preconditions to be workable as property. So there's an exercise in imagination involved. Now, that's the analogy. There is also a key difference between the digital assets as we conceive them here and, shall we say, shares, securities, which are traded on registers. Mm-hmm. I'll go to the register part of your question. Now, there's a kind of apparent similarity between the way a blockchain ledger system works, or a distributed ledger system works, and the way a share register system works, or the way that a land register system works. The recording of the transactions on the register is what gives legal effect to the transactions with those assets recorded there on the register. You transfer your shares on the register by changing the state of the register. That's one of the essential key conditions. Now, there is one big difference with digital or electronic ledger systems, and that is that they're not legally constituted. Unlike, say, the registers of Scotland, which exist under legislation, or the Crest share trading system, which exists under its own legislation, there is no legal constitution whatsoever to the existence of a blockchain. It's simply a fact, a digital fact. Now, just because there may be changes in the control and the holding of those digital assets on the ledger system is of itself of no legal consequence. The only reason why a change in the state of the land register, for example, or the Crest share register has legal consequences is that the register is itself legally created. It can therefore give that change legal effect. So, just because these are operating on a register recording system of itself doesn't give any legal effect at all to those transactions. And that's why we go at them from a different angle, not a register-based angle. We say we can imagine these things as being items of property because they are rivalrous and they do exist independently of the legal system. They have those certain tree-like characteristics that makes them work as items of property. So we conceive them as things, and then we just let the general law of property do its work in relation to them. It recognises ownership in them, and it recognises ways of transacting with those things. So it probably doesn't work to treat these as emanations or entities existing on a register and try and explain transactions with them legally in the same way we would ordinary transactions taking place on some legally constituted register like land or traded securities. Does that answer your question sufficiently?
Yes. I think a bit like the AI point, I think there's a number of other questions, but I think for the purpose of this morning, I think that both in terms of that particular question, but overall has been very useful and very illuminating.
Could I just add one further point,
yes, of course.
If time permits? Yes. Following up on what Professor Fox has said, you were referring to historical precedents. One way of looking at what we're doing is we're doing something very similar to what the great Scotsman, who in fact was an English lawyer, Lord Mansfield, did to English commercial law in the 19th century, or the 18th century. But he was head of the King's Bench from 1756 onwards. He looked at what business people were doing in the market and created legal rules to reflect their expectations. What has happened here is business people are using electronic systems to create value and create what they see as assets, which are can be sold for value, and there was no legal structure around it. This was just happening, and so what the bill does is really build up from the base. There is the electronic system which exists. These assets arise out of the electronic system, and then we define how they become recognised as property in our system. We are really looking at what people are doing in the real world and converting that into a property right. We're working from the base downwards rather than trying to impose on what they've created, as Professor Fox says, the status of a legally recognised register. And it's really for that reason that we've gone down the road we have gone down. I hope that's helpful.
It is. No, and again, can I just reiterate, I think overall this morning's session has been incredibly useful. I mean, are there any final points or issues that you feel the committee should have alighted upon or flagged in our questions? Again, I'm very mindful that we are all grappling with this as a topic.
I have none to ask, but as you all gathered from this session, Professor Fox is considerably more comfortable in this area with the technicalities of this area than I am. So I'll see if he has anything he wishes to add.
Only to reinforce the point that this is a relatively limited legal development. It doesn't in any way close off some of the other questions which you raised, notably how the law is going to respond to AI development in the future, a separate and enormously difficult question in itself, but also the point about the status of these assets in international private law. That is another enormously difficult question, but that is at least one where we know there is work being done now which we can easily draw upon and participate in very soon. So it's a contained piece. It solves one part of the problem, but there's still more work to be done.
Well, with that, can I just thank Lord Hodge, Professor Fox, for your time, insight and indeed patience as the committee has sought to get up to speed with this topic. It's been incredibly helpful. And with that, I move into private session so the committee considers agenda items 3, 4 and 5. Thank you very much.
Thank you very much.